On a frigid January night in 2022, Boston police officer John O'Keefe was found lifeless in the snow outside of 34 Fairview Road in Canton, Massachusetts. His body was battered, bloodied, and exposed to a brutal winter storm. What began as a tragic loss of a decorated officer quickly spiraled into one of the most controversial and emotionally charged trials in recent memory. His girlfriend, Karen Reed, a finance professor, now stands accused of second-degree murder. Prosecutors say she struck John O'Keefe with her SUV after a night of drinking and then left him there to die. But Reed's defense paints a darker tale. A conspiracy, a cover-up, a house full of secrets where fellow officers allegedly knew more than they let on. The first jury could not reach a unanimous verdict in 2024, and now the stakes are even higher in the retrial. Today, the defense started presenting their case, calling their first witness to the stand. And tonight, we are live from the courthouse with all the big moments as the retrial of the century continues. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. End of another week in the Karen Reed retrial of the century. And the name of the show, Closing Arguments, not an accident. It's because closing arguments are important. Big part of the trial. It's the final word, your last opportunity to convince the jurors that you have proven your case or you have demonstrated that the other side has not proved their case. It is the time where everything comes together, where you take the evidence and the law, you put it together, and you deliver it to the jury, and you hope that they understand your arguments, and you hope that they believe your arguments. Now, for the prosecutor, Hank Brennan, in this trial, in his closing argument, he's got to demonstrate that he's proven this case beyond a reasonable doubt. I talk about it a lot because it's really, really important. This isn't like you go in there and the jury says, yeah, I think she did it, so I'm voting guilty. No, you've got to be convinced. And the prosecutor's got to be convincing. So from his perspective, his closing argument, and he'll get the last word after the defense because he carries that burden of proof. But, you know, you've got to be extremely convincing in taking the evidence that came out during the trial and putting it together with the elements of each crime that the defendant has been accused of. And you've got to use that and put it together in a way that the jury says, yeah, I don't have doubts. I really don't have doubts about this. I get it. That's what you want. Now, on the other side, for Alan Jackson and the defense, it's just about exposing the reasonable doubt, right? You don't have to prove anything. The judge will make sure the jury understands that. I'm sure Alan Jackson will make sure the jury understands that. They don't have to prove anything. They have no burden. But you've got a job to do. So the other side's trying to put your client in prison, presumably for the rest of her life. They want her convicted of murder. It doesn't get more serious. So your job is to expose that reasonable doubt in your closing argument and explain to the jury why the evidence doesn't add up, why they have not fulfilled their burden of proof in the case. You don't have to prove a conspiracy. You just have to prove or demonstrate that they haven't proven their case. But sometimes it's really hard because prosecutors don't bring cases they don't think they can win. If they didn't think they could win, if they didn't think they had the evidence, they wouldn't bring the case to begin with. So it's a challenge each and every time for the defense. So now, as we think about these closing arguments, which are just around the corner here, the defense case is not going to take a month. What will they say? What will Alan Jackson, what will Hank Brennan say to this jury at the end of the case? Well, guess what? We got a big preview today. And later on in this hour, we are going to go through some of the arguments that we heard in court today that certainly the jury will hear at the end of the case. These arguments were in front of the judge, but trust me, they are a preview of what is to come at the end of the case. But before we get to the end, let's talk about today. Court TV crime and justice correspondent Matt Johnson joining us live from outside the courthouse in Dedham, Massachusetts. Huge day in this trial again. I'm getting tired of saying it, but it is. First day of the defense case. So let's talk about the first witness called by the defense, because you want to make an impact right out of the gate. What can you tell us, Matt?
Well, it was an engineer who specializes in vehicle data, and this was a brand new witness for the retrial. We haven't seen this person before, by the name of Matthew DeSogra. In really important testimony, he spent all day on the stand really talking and trying to make one point for the defense, and it was comparing the data from John O'Keefe's cell phone and the click, the lock mechanism that happened at 12:32:09 a.m. on the 29th, and comparing that to the data from the SUV that was part of the Aperture report. So right here on your screen. So he looked at 30 possibilities, and he broke it down like this. 25 of the 30 possibilities, the lock event on John O'Keefe's cell phone happened after Karen Reed's SUV recorded the reverse trigger event. Only 3 out of 30 happened before the reverse event, and 2 at the same time, according to him. Let's listen.
Is there any ability to say to a reasonable degree of scientific certainty that the tech stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
You said it's 3 out of 30, correct?
Yes.
Is that 10%?
That is 10%.
Yeah, move to strike.
Yeah, if there's sustained and a movement, it's stricken.
This was a back and forth. There was a cross, there was a redirect, there was a redirect, there was a redirect. There was some shade at the end of some of that questioning. Alan Jackson asked this witness of his if he ever has lied or falsified a resume or a cover letter, and also if he had a bachelor's degree, Vinnie.
Yeah, well, it's fair game. It's a battle of the experts, so you know, credentials and credibility is on the line. But this is a big point for the defense, and it's a big point for this jury. Is John O'Keefe locking his phone after the alleged triggering event or before? And this expert is saying, well, there's a chance, but it's 1 in 10. 1 in 10 is not beyond a reasonable doubt, so I think the defense will lean on that. We're going to talk about that in a moment with our insiders, but let's talk about the cross-examination. And I've been very interested in waiting to see Hank Brennan cross-examine a witness in front of a jury, because he's really more of a full-time defense attorney these days, and defense attorneys are really good at cross-examination. So what happened?
Yeah, the mood in the courtroom definitely shifted, right? Because you saw Hank Brennan turn on that defense attorney switch with his cross-examination. You also saw Alan Jackson delivering now with his direct examination. Very different mood. They were changing roles right in front of this jury. And what Hank Brennan was really trying to make the point of is the fact that this particular witness couldn't rule out any sort of collision, pedestrian collision altogether. Take a listen.
When you talk about tech stream data, you know that tech stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Are you sure you know a lot about tech stream data?
Yes.
Now, there was also some shade on Brennan asking questions, calling him a Monday morning quarterback, and really zeroing in on the fact that he didn't do any of his own testing. He was just relying on Aperture.
Right. He was going over their work to see if they did it correctly. I mean, that's that expert. They've got more experts coming up. But, yeah, it was an interesting back and forth. But all these experts that we've seen are very familiar with all this stuff. So I think the jury will understand that. All right, let's talk about, you know, when the jury's there, obviously extremely important, but sometimes there's really important things happening when the jury isn't there. Today, I think, was one of those days. What happened outside the presence of the jury this afternoon?
Yeah, outside the presence of the jury, very heated arguments in the courthouse here behind me. This was once again Brennan and Alan Jackson squaring off, and the big argument was once again over Trooper Proctor. And that text chain that really ended up in his firing from the state trooper's office, it was heated arguments as to whether or not one of his childhood friends, Jonathan Demandis, an everyday person who was called to the stand to answer questions, could authenticate the text messages that Trooper Proctor had sent, and they want to bring this guy in as the witness to do it. Let's hear the arguments on that.
This witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. My position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again.
And you know, some of the text messages that David Yannetti was arguing that he really wants to bring in is the one, and I'm paraphrasing here, where Proctor says, pin it on the girl. There's the other one about the homeowner, Brian Albert, that he won't get any slack for any of this because he's also a Boston cop. Those are some of the critical things that they want to get in front of this jury.
Matt, this is fascinating. Both sides dare. I dare you to call Michael Proctor, says Hank Brennan to the defense. Then the defense is like, well, I dare you to call Michael Proctor to the stand. I've never seen this before. This guy's in the middle of everything, lead investigator. Both sides kind of want him on the witness stand, but both sides want the other side to call him because they both want to lead him. This is wild. I don't know how this is going to end. I have a feeling he may not testify. How about that? Wow. All right. An amazing moment, Matt. Another amazing moment in this case. Any word from the defense today?
Yeah, you know, I've been asking Karen Reed, again, everyone's under a gag order except for this defendant, multiple times whether or not she thought that the state was going to call Proctor. She said no. Remember that moment? And then I said, well, will you in your defense team, in your case in chief? She said TBD. Well, after court today and after those arguments, of course, I pressed her on it again. Take a listen. Why not just call Michael Proctor, Karen? How do you feel at the end of your first day of defense?
I always feel good. I feel strong, and I feel fortunate.
And that's what she was telling me earlier in the day as well. She had another big moment where she saw some of her supporters. She walked across the street after the mid-morning break. She started hugging people. There was a lot more supporters here today. And keep in mind, this trial is just so different. We talk about it a lot, including the fact that a lot of these supporters are circulating videos of this defense team doing things like cooking. It's part of their fundraisers. I want to play one, and I'll talk a little bit more about it.
Jackson, all right, hope was firing on me like it. Yeah, that's what we're doing.
Defense team in the kitchen cooking right there. These are posted all over social media. So, of course, I asked Karen Reed about it. I said, are these real or are these AI? She said they are very real. The defense cooking on their time off as part of fundraisers for their team. Alan Jackson in the cooking and in the kitchen at one point cooking meatloaf. So I asked him about it. Take a listen. What can you tell us about the cooking and the meatloaf?
Secret ingredients all the way around.
Okay.
And if you're lucky, you'll get some someday.
He took that question by surprise. I mean, you saw him laughing right there because he can't answer anything associated with the case that happens behind those doors and those walls behind me here at this courthouse. But he could answer that. And, you know, we're talking about it because it's one of the things, Vinnie, that makes this case so unique, right? We have a case where a defendant has supporters like she does throughout this trial and the last one. You have a defendant that's out on bond and one that has fundraisers such as this where they're posting things on social media. It's just one of the many aspects that makes covering this case, and this case in general, so unique.
Yeah, and I think a lot of people will look at this case, and it may be, we might see a lot more of this in some of these high-profile cases in the future. Alan Jackson, lead attorney, lead chef. It looked like Yannetti was working on the sides, and I bet Alessi was cooking up the cocktails. Matt Johnson, thank you so much. Let's bring in our Karen Reed trial insiders. First, Massachusetts criminal defense attorney Joseph Krowski Jr., and he served as special trial counsel to Johnny Depp in his defamation case, trial attorney Wayne Dennison. Also with us, Karen Reed supporter Nick Rocco, and finally, YouTuber and author of the book Storm of Suspicion, The Karen Reed Trials, Kevin Lenahan with us. Okay, I want to begin with the lawyers. We'll start with the lawyers first. Both sides here daring each other to call Proctor. Joseph Krowski, who's going to take up the dare? Both? Neither? Who?
Probably neither. You heard David Yannetti today, if you were watching, his concern with calling Proctor's. If he calls Proctor, it allows Hank Brennan to cross-examine him and essentially tell their case and their theory of the case through Michael Proctor in a very leading manner. It also is going to open the door for him to explain what was his state of mind when he made those inappropriate texts. What information did he have about Karen Reed? What information did he have about what he knew what were the facts on the ground compared to the way she was behaving? So that's why the defense is calling the friends of Michael Proctor to try to get the texts into evidence. And you've made a big point about why isn't the prosecution calling the lead investigator? It actually happens more than you think. There are instances when police witnesses are either fired or suspended.
I get it, but he was called in the first trial. He was called in the
Right.
first trial. Like it's
he's
not
since
crazy
been
to say he's going to be called.
But he's since been terminated. They made a tactical decision. They're not hiding the ball. The defense has all the information related to him. They can call him. They don't need him. I don't think he gets called.
Wayne Dennison, have you ever dared your adversary to call a witness, like in court? Like, I dare you to call him?
No, I've never done that, but I agree with Joseph. Ultimately, I don't think he gets called. It's a function of the way Massachusetts trials work. If they call him, Hank Brennan gets a chance to cross, and he can put all the words he wants to in his mouth and just say, don't you agree? And I think that we will not see Michael Proctor testify.
All right, Nick Rocco, let's talk about Matthew DeSogra. How important is this witness for the prosecution? What did he prove? I mean, for the defense. I'm sorry, for the defense. What did he prove?
Well,
You had it right.
So he got brought in for one specific reason, and that specific reason was to go over Burgess and Welcher's data in reports that they provided to the prosecution and to the defense team. And what we saw today was Hank Brennan basically telling DeSogra that, you know, he didn't do his own research, but that's not why he was brought on. He was brought on to go over exactly what they did. And what he did was he pointed out the fact that 25 out of 30 different possibilities point to the fact that John O'Keefe used his phone after the trigger event, and only 3, which is what they said, 10%, would have been that he locked his phone before the trigger event. But one of the big things that Hank pointed out was the fact that he's trying to insinuate that the data he's using is wrong, but all of that data that he's using is coming specifically from the prosecution witness Aperture's reports. So if the data that DeSogra is using is wrong, then that means basically Hank is admitting his witnesses are wrong.
Let me ask you, Kevin, did DeSogra do any damage to the prosecution's timeline?
I thought he did tremendous damage to the defense, to tell you the truth. One of the problems with this case, I guess in any case, is, but we we all have had to absorb so much information to master what was going on in this case, and a jury doesn't have that benefit. So they're learning all these new terminology like trigger events and learning how there's a 10-second window around before 5 seconds before and after a trigger event. There's an awful lot to master. And what happened today was this was almost more teaching for the jury by the defense witness about how to master these events. And it's just important to understand here that, just as an example, someone dies of a gunshot wound, they go to the medical examiner's office, and the medical examiner can't determine whether it was suicide, whether it was self-inflicted, or whether somebody shot him. But then you have to go to all the rest of the evidence, and you learn that the defendant had gun residue on his hand and there's witnesses and blah, blah, blah. What happened here is you're looking at something in isolation. This is what DeSoria did. Instead of looking at the totality of the evidence, and I think Hank did a good job of pointing that out. When you look at the totality of the evidence, that's what Burgess did. Now you have a much more truer analysis of what happened.
All right, our insiders are staying with us. When we come back, we are going to take a look at a preview of the defense closing argument. Plus, coming up next hour. Tonight on Vinnie Politan Investigates, as the retrial of the century continues, we take a closer look at some of the big lingering questions connected to the murder of John O'Keefe. Like, why didn't anyone see his body next to the road? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Reed murder retrial. Live coverage weekday mornings, 8/7 Central, on Court TV.
What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none. Zero. No reasonable jury could find Karen Reed guilty.
That was Alan Jackson in court today, not arguing in front of the jury, but arguing in front of the judge. It happens at the end of the state's case or the Commonwealth's case in every trial we cover here at Court TV, where the defense tries to get the judge to dismiss the charges because they haven't proven it, even to a degree that a jury with all the evidence in the best light could come to the conclusion that the defendant was guilty. They always lose that motion, by the way, just about all the time. So this gives us really, though, a sneak peek at the defense case and the defense closing argument. So take a listen here to Alan Jackson, and I think this is going to be the centerpiece of their closing argument to the jury.
Following, the Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence.
And Alan Jackson went on to talk about the fact that there were no eyewitnesses. No eyewitnesses seeing the SUV back up. No eyewitnesses obviously seeing the murder. And no eyewitnesses seeing John O'Keefe's body on the front yard in the snow until the following morning. So is this a compelling argument? Still with us, Joseph Krowski Jr., Wayne Dennison, Nick Rocco, Kevin Lenahan. Wayne, what do you think?
I think that this was a very well done motion to dismiss and is in fact a preview of the closing argument. I think the argument
will it
around
persuade
the murder
a
charge is, in
jury?
fact, compelling.
Obviously, these things never persuade a judge. Will it persuade a jury?
Well, I think it will be very persuasive with respect to the murder charge. With respect to the manslaughter charge, with the lesser charges, that will come down to the jury's entitled to make judgments and reasonable inferences from the facts that were in fact put into trial and put before them. And they'll, you know, the prosecution will take the position that you can make a reasonable inference that he was hit by the car.
Should the prosecution be concerned here, Joe?
No, not at all. And this goes back to DeSogra. First of all, experts are not hired to merely look at the reports of the opposing sides, DeSogra did not harvest any data, did not do any independent testing, so he was ill-equipped to actually criticize the reports. In what you're calling raising to reasonable doubt the 10% of scenarios where she could be backing up while John's phone was still moving was based on a flawed analysis. He compared data from Karen's phone stored in the car to John's phone, which would only give you a 1 to 2 second variance. If he had compared it and read the report right to the infotainment center, that's where you get the 21 to 29 second variant. Two other points on that, very devastating for the defense. The collision, this expert conceded that TechStream doesn't record collisions and event data recorders don't record collisions when it's a pedestrian strike. And also, if you heard the direct examination of Alan Jackson, they conceded now that there was a triggering event at 12:31:38, which would have required them to show that she depressed the gas pedal at least 30% and backed up the 50 feet. So there's no way this is going to be helpful to the jury. It can't be the world's biggest coincidence that she backed up 50 plus feet, gunning the gas pedal in reverse, 35% depressed, 24 miles an hour, with the taillight found by John O'Keefe's body.
I think we just heard the closing argument. Okay, I want you to take a listen to this because there was another part of Alan Jackson's argument that he made today, and this goes to, well, who could have done it? Take a listen.
There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. The Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation.
Kevin Lenahan, is this a reasonable alternative explanation for what happened?
No, it's more of straw man and tin man. The straw man, as we already said, Alan Jackson said that that the state is implied that the state is saying that Karen had intention to run over John. No one has ever said that. And same thing, and the state has never said that the vehicle data showed, well, the state may have said in the first trial, but in the current reconstructions does not say that the state showed that that there was in the data that there was an accident, but there's all kinds of physical evidence that proves that there was an accident. As far as pointing to Higgins as a third-party alternative or anybody else as a third-party alternative, all of those doors are closed as a possibility because of this other evidence that shows, as Joe said, that we know that John got out of the car just seconds before and locked his phone just 7 seconds before his phone moved for the very last time. So this closes every possible opportunity to establish any alternative theory here.
Nick, Rocco, your thoughts?
Every witness and every piece of evidence in this case has reasonable doubt attached all over it. I mean, from Shannon Burgess, lying about his credentials, and which goes to his credibility as to if his date is correct. The glass on the bumper doesn't match the cocktail glass. You have Brian Higgins sending a text message, basically saying, are you coming here? And then no taillight was found in 3.9 inches of snow, which the meteorologist who stated, which I think was a huge point for the defense, that when everyone left that house, there was only 0.8 inches of snow on the ground, and not one person saw John O'Keefe on the lawn, including Lucky the plow driver, around 3 a.m, because John was not on the lawn. And all of these points, Ryan Nagel, Heather Maxson, they drove by Karen Reed. John O'Keefe was not in the car. So if he wasn't in the car, he had to have been somewhere else inside the house, or maybe in the backyard, who knows? But he wasn't in the vehicle, and he wasn't around the vehicle. So every single piece
he wasn't seen, which is different.
And witness has reasonable doubt, and when there's reasonable doubt in the case, you cannot convict someone of murder, manslaughter, leaving the scene of a crime, and this is everything that Alan Jackson's going to point out in his closing arguments, and there's no basically refuting it, because every single thing there is the truth.
Insider staying with us. When we come back, we'll take a look at a preview of the prosecution's closing argument.
Under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
Okay, we're taking a look at the big picture right now. A preview of the closing arguments to come, because at the end of the prosecution's case, the defense trying to get the charges dismissed in front of the judge. So both sides gave us a look at what they believe are their strongest arguments. Let's take a listen now to the prosecutor, Hank Brennan.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. A reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion, and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Suffice to say, there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol, manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions that night, after being intoxicated, that conduct was intentional. And any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. Statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypotheses about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe.
All right, let's bring back in our insiders. Nick Rocco, let me ask you, how much of a problem are Karen Reed's own statements being played like, I saw him and he was not mortally wounded? The prosecution leaning into that, leaning into the intoxication.
Well, we know the Commonwealth likes to take video clips out of context, and when she stated that he didn't look mortally wounded, she's talking about the next morning when they pulled up to the house. These statements to a jury, they may not resonate with them, but at the end of the day, it comes down to the facts and the evidence of the case, and you have to prove it beyond a reasonable doubt. And we all know, Vinnie, you went and did the test yourself. You drove down that road that does not show your Apple Health data going up steps. But yet John O'Keefe's phone shows that he's climbing 3 flights of stairs. There's just, everywhere you look in this case, there's reasonable doubt, and I think that's going to be Hank's biggest hurdle, is to convince the jury that he did a well enough job to put her away for life, if not, the minimum sentence for manslaughter. And I personally believe we're going to have the same outcome as the last trial.
Joseph Kraske Jr., is Hank Brennan hitting the right notes for the prosecution to convince a Massachusetts jury?
It's a combination of scientific and engineering evidence complemented by circumstantial evidence and then highlighted by the defendant's own admissions and, even worse for her, confessions. We've got to stop talking about statements not being evidence. Confessions of defendants are some of the most powerful and potent evidence there can be. What I think is deeply concerning for the defense, and I don't know who advised her to do it or if she did it on her own, is the clip that they ended with. It essentially was her telling the story of what happened. Could I hit him in the knee? Could I have run over his foot, clipped him, incapacitated him, and he was drunk, passed out, and was left there to die? Essentially telling the story, the narrative of what the Commonwealth is alleging she has done. So statements by defendants when you're a defense attorney are never a good thing.
Kevin Lenahan, what is the strength of the prosecution? Is it the intoxication? Is it the digital footprint, the text stream data, or is it the statements made by Karen Reed herself?
So I actually agree with Nick on the mortally wounded statement, that's not what she meant. And I've never put a heavy weight on most of the statements. They should be used, and they are being for the practical effect of the jury. But for me, what this comes down to is, if you look at the totality of the evidence, instead of just trying to find reasonable doubt by looking at an isolated piece, there is no reasonable doubt, because it's a simple case where every other possible explanation is completely closed now. And the prosecution has methodically closed all of those with the data, the physical evidence, and the timelines. And when you sit down and look at all of that evidence, there's just no other possibility except for Karen struck John with the Lexus.
Wayne Dennison, what should the defense be most concerned about here, and what do they need to do in their defense case to deal with that issue?
I think that there should be real concerns about the various statements that the defendant Karen Reed had made publicly and were subsequently then broadcast to the jury, those you need to somehow blunt. You're going to have to somehow explain them away. I think Hank Brennan started exactly right. I mean, he can prove intoxication pretty easily, and then he builds his case from there. But the defense is ultimately going to have to explain away Karen Reed's own words.
Well, one way to do that, to neutralize it, we only have 30 seconds left here, is for her to take the witness stand. 0 to 10, what do you think the chances are of Karen Reed taking the witness stand? Nick, I'll begin with you.
-4.
-4 from Wayne.
-4.
Nick?
I think if the prosecution put on a stronger case, maybe she would, but I don't think she's going to.
You don't think so, Kevin?
I'll go -3, just so I can get the odds on Wayne.
There you go. And Joseph, what do you think? You've got 5 seconds here.
1.
1. All right. So you're saying there's a chance, Mr. Krowski. All right. Joseph Krowski, Wayne Dennison, Nick Rocco, Kevin Lenahan, great to have you. Thank you so much. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, the prosecution finished their case without calling Brian Albert, who were inside 34 Fairview when John O'Keefe was found on their front lawn. Why didn't they hear anything? Why didn't they come outside? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
What do we really know about Diddy parties?
Get a new look at the evidence and the latest from inside the courtroom. Vinnie Politan Investigates, a Diddy special report. Wednesday night, 9/8 Central on Court TV.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at the big board. You know who is there. It's Sean Diddy Combs and the Diddy sex trafficking trial continuing. What we have for you is some testimony from a former assistant of Diddy's who used a pseudonym or a name that's not hers, Mia, for testifying. Let's take a listen to her testimony as we hear from the actual transcript with the help of AI.
Did you ever call the police after you saw incidents of violence between Mr. Combs and Cassie?
No.
Why not?
For multiple reasons. I believe that Puff's authority was above the police. This was also a time period. This is years and years before social media, Me Too, or any sort of example where someone had stood up successfully to someone in power such as him. Also, like, I was taught to believe that this fell under the confidentiality or loyalty of, like, Puff's business.
What did that confidentiality mean to you?
That was the most important thing. And Puff had told me that I was supposed to protect him from people because there were so many people trying to blackmail him. So I came to believe that reporting anything was blackmail.
Did you ever go to the police about Mr. Combs's violence towards Cassie?
No.
Mia, besides what we have talked about so far, are there any other times you remember seeing injuries on Cassie?
Yes.
What kinds of injuries did you see?
I would see bruises on her body and, like, fat lips, busted eyebrow, like a gash on her forehead, black eyes, things like that.
And we have an important programming note. Next Wednesday, this Wednesday coming up next week, 9 p.m. on Vinnie Politan Investigates, we're doing a Diddy trial special report. We'll have insight from insiders going inside of that courtroom. Great analysis that's coming up Wednesday at 9 right here on Court TV. Right now, I need you to take a look at your television screens. We have a missing child who needs your help. This is Brooklyn Edith Sanchez, missing from Houston, Texas. She's only 16 years old. If you see Brooklyn, please pick up the phone, make a call, 911, 1-800-THE-LOST, or you can call the Houston Police Department in Texas. That phone number's on your screen right now. Let's see if we can get Brooklyn to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.